Alex here with part 19 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. I always like to glaze over 2 points just in case people don't watch part 0. Number 1, my case is completely and totally closed. I'm not in the middle of this right now. My case cannot be reopened. My ex's parental rights have been terminated. Number 2, the nutshell version of the purpose of the series is that I wanted to provide my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 17 with the motion to have my ex held in contempt of court for a willful violation of the court's order on our interim visitation schedule. This video goes into my ex's opposition, which is prepared and filed by her attorney. I typically go into some detail as to my mindset between the period of my last video, which actually involved filing a motion for a modification of the temporary custody order, and this particular video. And there really wasn't a large gap of time between. In fact, for the most part, I felt empowered because I had realized by this point that I could actually make things happen by myself. This was something that I had no clue was a thing. I just had no detailed understanding of the legal system. And by this point in time, I realized that I didn't really have to argue with my ex. And it sounds bad to say that, especially for people who haven't seen all of my videos. They don't understand the situation. Most people think that two parties to a separation are both reasonable, and they may have different points of view, but they can work together and come to, a resolution that's best for the child. But in these high conflict cases, it's not true. The other party has either severe emotional immaturity issues or a personality disorder or some kind of other mental health issue. And communicating with them is different than communicating with another person who communicates in good faith to solve problems, to find out what's going on, to get information or clarification on information. A high conflict ex isn't concerned with any of those things. They communicate to fend off attacks, to stall, not to resolve, but to actually create more confusion and chaos. And so another viewer actually described it to me as it's as if they're playing a game of chess with you, and what they're telling you isn't actually what they care about. What they're asking you isn't actually what's concerning them. What they're interested in is your response. It's your reaction that matters. And so communications from these types of people have nothing to do with resolution. They have everything to do with trying to trigger a response or set you up or bait this or bait that. And sometimes on occasion it'll be to look a certain way. And so it might be best to just pause right here and go ahead and take a look at what my ex's attorney has filed. This here is my ex's attorney's opposition to my motion to have her held in contempt of court and for attorney fees. There are a couple of things that I want to take note of. First of all, this is a custom paper. It is not a form paper. It is not one of those fill in the blanks, check the boxes. It's a document that was prepared from scratch by our attorney. And the other thing that I want to mention is that, as far as I can recall, this is not allowed in the Second Judicial District Court. There is a local rule that forbids combining an opposition and a motion. You are allowed to file an opposition and then have some kind of alternative relief requested. I know they do this with motions as well, but you can't combine two papers into one paper. At least when I was representing myself in Second Judicial District Court, the local rules made that clear. 8th Judicial District Court has its own set of rules, and they do allow what they call a counter motion. You are allowed to file an opposition and a counter motion in the same paper in the 8th Judicial District Court. Now, if I'm wrong, somebody can feel free to correct me. And the real reason that I'm bringing this up is because I want my viewers to take a look at their local rules and determine whether or not this is something that they can do. The reason I think some jurisdictions don't allow it is because it gets confusing. And the reason it gets confusing is because the deadline to respond varies depending on what it is you are responding to. So when you get an opposition and counter motion from an opponent, you have to deal with those separately. You can, I suppose you can file a reply and opposition, which just makes it even more confusing. But that's going to end up costing you 5 days because, at least in Nevada, the deadline to file an opposition is 10 days from when the motion was served, and the deadline to file a reply is 5 days from when the opposition was served. So if this isn't confusing my viewers already, I don't know what to say. You're really able to follow the technical details as to motion practice, probably more than the other viewers. But I think it probably provides an example to a lot of my viewers as to why some jurisdictions don't want this to be done. And if yours is one of those that does not want you to combine an opposition and a motion, or what they call a counter motion, in the same document, then all you have to really do is file an opposition, as its own dedicated paper, and then a separate motion as it's also its own dedicated paper. That would be the appropriate way to deal with something like this. But I wanted to bring it up because I know it's a thing in Nevada in certain judicial districts. So let's scroll down. The first paragraph is pretty standard. I've talked about this in previous documents. It basically lets the court know who is filing this document, whether or not they're filing it on their own behalf or through counsel, and also the title of the document and what it's based on. This language is pretty generic. The opposition is based upon the following points and authorities and all pleadings filed herein. You see a sentence like that in pretty much every single motion or opposition or even reply that is filed with a court, or something similar to that type of verbiage. Points and authorities. Now this is really bare bones. It does not separate, or she doesn't bother to separate it into a factual background and legal analysis. She just blobs it all together, and it's probably because she only put 1 page worth of work into this opposition. The first thing she says is that I am trying to hold her in contempt for 2 one-hour variances from the visitation schedule, variances to which he agreed. Now, the first thing I want to point out to my viewers is, if I had actually agreed to this, the lawyer would attach an exhibit. She would attach a stipulation, or she would refer to a stipulation. She would tell the judge, he agreed, and here is proof. The reason that her attorney does not include an exhibit or a reference to a document which indicates that I agreed is because I didn't agree. There is a tactic that I call narcissistic pretexting, and I'm not going to allege that her attorney is a narcissist. In fact, what I mean to do is say I'm not going to allege that her attorney has narcissistic personality disorder. If you take a look at the video, Narcissistic Pretexting, I really quickly give a disclaimer that this video does not have to do with the personality disorder. Rather, it has to do with a type of pretexting. In other words, it's just a mere adjective of a type of pretexting, and this is basically making a claim on a basis that isn't true, but it doesn't need to be true. The lawyer doesn't need for me to have actually agreed. She just needs to indicate to the court that she thought I agreed. And that's kind of where this attorney is going with this statement. I mentioned earlier that if in reality I did agree, there would be documentation to support that I did agree. But this lawyer has no other better way to defend herself and her client other than to tell the court, hey, I agreed, and then later on, if the attorney or the client is called out, she can say, well, I thought he agreed. I didn't know that in actuality he didn't. You just need to make a defense that is plausible. This is very standard anytime you're trying to hold someone in contempt. It is extremely rare for somebody to say, yeah, we screwed up on purpose, punish us. They will always find some kind of pretext or plausible explanation to use to defend their client, no matter how bad it sounds, no matter how weak it is. So in this case, she's saying that I agreed even though it's not true. I am going to go ahead and elaborate a little bit on this because I talked about it a little bit in part 17 of the My Docket series, but I want to go ahead and reiterate that what happened at the hearing that this came up was that my ex proposed the time for my visits be pushed back 1 hour on drop-off, and my response to that was that it would be okay as long as my pickup or her pickup would be also pushed back 1 hour, so I wouldn't lose any time. Basically, we would go from 8 to 5 to 9 to 6. So again, no time would be lost. That was the proposal. We went to court and the judge declined to actually order that. What he did instead was completely transform the visitation schedule. He doubled, if not tripled, my time, and so the court declined to enter this order on our agreement. What I'm going to say is that even though the court didn't enter this order, I would still be a reasonable person and allow my ex to push back the drop-off time as long as she pushed back the time which she picks him up. In fact, I talk about this in part 17 of the My Docket series, and I provide supporting documentation indicating in writing that I offered to her, hey, I'm upset, you violated the court's order, the judge did not enter this, but everything is going to be okay if you do a pickup at 6 p.m. Her response was, nope, you're going to lose a time, an hour, on drop-off, and too bad, you're not going to get that time back on pickup. And so this defense by the attorney is a half-truth. This is what they do. I talk about the reasons as to why lawyers do this in the video, Win at All Costs. Lawyers do not care about telling the whole story. Lawyers care about winning their case. If they have to bring up partial truths to win their case, they will do this. I am hoping that I address this on reply, and I'm fairly certain that I do, but I'd rather not look into the future, and later on in the series when I get to my reply to this opposition, we'll take a look and see how I responded to my ex's attorney's allegation that I agreed to this shift in time. The next line is a statute. She cites NRS 22.010, which is the definition of contempt. And she alleges that because of the agreement, it was okay. What she's saying is that you can violate a court's order if you have a valid excuse. And it is true. If there is a court order that requires a party to do a certain thing and the other party says, you know what, I don't mind if you change it, that is a defense to contempt because you're telling the court, yes, I violated your order. However, I have a reasonable basis for violating your order. And that reason is that my ex allowed me to do it. And scroll down a little bit. Of course, this doesn't apply in this case because I didn't actually agree, but that is the statute that she is citing to support her defense. The next line is, or next paragraph is, even if the parties had not agreed, it borders on abuse of legal process and harassment for a variance of 2 hours. Now, this is laughable, but as I mentioned earlier, if you watch my video, Win at All Costs, you'll understand that the lawyer will make a claim to defend their client that they would not ordinarily make if you had done the same thing to them. I think some people call this do unto others as you would want others to do unto you. I think other people call this put yourself in your opponent's shoes. And what I am leading into here is, had I done this to her, my ex's attorney would not tell her client, hey, we can't go after him because it is harassment that he violated the court's order even though it was for an hour. What she would tell her client is, how dare he? We're going to take him to court on contempt of court and punish him. And the reality is, you can say it's not a big deal for you to have deprived your opponent of an hour of their time, but at the same time, your opponent could say the same thing about you. And so it's one of those things that goes both ways. If you don't care that you're depriving your ex of an hour of their time, you shouldn't care if they deprive you of an hour of yours. Of course, as I mentioned earlier, when it comes to win at all costs lawyering, these kinds of logical principles of fairness and morality and ethics do not apply. What applies when it comes to attorneys is that they win, and they will say and allege anything that they can to win on their issue, even if it is a thing that they themselves would not allow their client to be subjected to. It does not go both ways with attorneys. They are perfectly willing to point the finger at you for having done something that they hypocritically would not allow you to do to them. And you just have to put up with it, and you really have to hope that you have a good judge that can see through this nonsense and be willing to side with the person who's actually correct. So she says it's a cause of concern that my litigiousness may preclude any settlement of this matter. Now, I think that this is a two-pronged assault. Number one, she is playing the judge's fiddle. This particular judge, and in fact, most judges really like settlement. And I'm not talking about, well, actually, I guess you could apply this to judges that are not in the family division, but especially judges who are in the family division. The reason why is covered in two separate videos. The first video that I would recommend watching is Wing It Judges. Most judges, especially in the family division, do not actually consider themselves academics. They do not like to do research and apply the law. They like to just roll out of bed, plop down on the bench, and wing it. And if you are not settling the case, you are creating more work for them. They do not want to do any research. And what that means is they need you to settle the case. If you settle the case, that means they didn't have to do any work. They can just kind of talk to you both and say, good job on you guys settling, and then you can go away, and you can't challenge their decision. Decisions that are entered at the or by the consent of the parties are not challengeable on appeal because you both agreed. So this judge or this attorney is playing the judge's fiddle. She knows that this judge likes settlement, and she is saying, look, he is a person who won't settle. So therefore, he is a bad man, a bad father. The other thing that she is doing is she is bringing up the magic word litigiousness. And this is something that I talk about in the video, Defend Against Attorney Fees. If you are representing yourself, the first thing that your opponent's attorney is going to do is point the finger at you and say that you are litigious or vexatious. They do this because most people who represent themselves and file a bunch of papers actually are litigious and vexatious. They do not understand that they are abusing the legal system. They do not understand that they are impacting the lives of other people, not just their opponents, but their opponents' attorneys, the judges, the staff. And so what they try and do, these attorneys, is they try to lump you into all those other people. And they know that the judge doesn't really have a whole lot of time to look into the details of a case. When they see that you have filed a whole bunch of documents and the opponent's attorney is saying, look, he's litigious, they just lump you into all those people, and they will try and use it as a basis to punish you, either to sanction you, impose attorney fees on you, or to have you declared a vexatious litigant. I would like to take this opportunity to tell my viewers that you need to watch those two videos if you haven't seen it yet, because if you are representing yourself, it is guaranteed that your opponent's attorney is going to immediately, as soon as they possibly can, have you branded as a vexatious litigant or have you punished and ordered to pay their attorney fees. Please watch the videos Defend Against Attorney Fees and the other video, Vexatious Litigants. Now I'm going to go ahead and keep a tally because this is something that comes up in my case over and over again. I am constantly fending off these efforts by my ex's attorney to declare me vexatious litigant or to have me punished to pay her attorney fees. So we are going to count this as the first time that my ex's attorney has sought an award of attorney fees against me. And I really want to underline this because anybody out there who is representing themselves is going to have to do a tremendous amount of research on how to defend themselves from having to pay attorney fees because it will financially cripple you. It will break your back and it will terrify you into submission, which will just lead to your child being abused and neglected in perpetuity and into oblivion. So let's keep a tally because this is going to happen so many times that I'm sure people are going to lose their lunch. They're going to be nauseous, especially considering the abuse and neglect that my ex is committing on our son. So again, I really need to underline for the viewers, attorneys do not actually care about what is best for children. They will facilitate abuse or neglect of a child if their client lies to them about being the protective parent, about you being the abuser. Now, I want to go ahead and give attorneys a little bit of a break here. If their client sits down and tells them, yeah, thanks for representing me. I love abusing my kid. You're enabling me. Any attorney is going to not be okay with that. But these types of people don't do that. They go to their attorneys and they play the victim and they say, poor me, my child needs help, please save me. And the attorneys just take them at their word and they will proceed in accordance with their client's allegations, and that if that includes them unknowingly facilitating the abuse or neglect of a child, then so be it. And You know, I covered that in the video, Win at All Costs Lawyering, so I'm not going to go any further into that. But yes, if you want to know more as to how this happens, please watch the video, Win at All Costs. So let's scroll down to Certificate of Mailing. This is a standard certificate. It just lets the court know that my ex's attorney mailed this document to me. This actually makes sense. There were some documents that she was serving upon me personally. I'm not sure why she was doing that. She is mailing me this copy of this opposition. She is allowed to do this. If anyone is wondering why you can just mail a court document to somebody and you don't have to serve them personally, you have to take a look at your court rules. In Nevada, we have two court rules, NRCP 4 and NRCP 5. NRCP 4 is the one that is kind of what everyone thinks applies to all court papers and documents. And what I mean by that is most people have seen video or movies like Pineapple Express, where they have to, you know, track you down and serve you the documents. That is NRCP 4, but what most people don't know is that does not apply to all legal documents. It only applies to the initial service of the pleading. Everything else is governed by NRCP 5. It's a completely different rule, and that allows you to serve everything else through the mail. So if anyone has any further questions on this, definitely post something down in the comments below. But I'm sure that other jurisdictions and other states have similar rules in place that require you to personally serve the initial pleading and allow you to serve everything else through the mail. Scroll down, we've got the affidavit. My ex's affidavit is mandatory. It is required under the rules. You have to support factual allegations or factual assertions in a motion or other paper with an affidavit, and she is doing so. It basically will allow me to hold her feet to the fire if she's a liar, and this is something that comes up throughout the the entirety of the case. But here she is doing what she's supposed to do. Her attorney is including the affidavit that has my ex swear under penalty of perjury that everything in here that's factual, at least, is true. Scrolling down. Oh, it's interesting. Hold on a second. It's interesting that she used an affidavit because she could have just done the declaration in lieu. So if anyone here is wondering what I'm talking about, please watch my video, Affidavits and Declarations. There's another way to do this, and it's easier and doesn't require a notary stamp. But I'm not going to go ahead and cover it here because I have a separate video that is dedicated to that. Scrolling down. This is the affirmation. It's just a gigantic piece of paper that tells the court, or the clerk actually, that gigantic piece of paper. What I'm contrasting this with another way of doing it. There's another way to include the affirmation. It's a one-line statement. You don't need a whole piece of paper dedicated to just this. And anyway, for some reason, my ex's attorney doesn't do this. She includes the form document, the form affirmation. And it just tells the clerk of the court that this document does not have a social security number. The reason they do this is because the courts, or the clerks of the court, don't have time to check. They're too busy. They're not going to rifle through an entire paper and find out if there's a social security number. They're just going to look for the affirmation, and they're just going to take your word for it. Scrolling down, we have the motion opposition notice. I've gone over this probably a dozen times by now. This is just a document that you check a bunch of boxes in, follow the instructions, and based on the boxes that you check, you will determine whether or not you had to pay a filing fee. In this case, my ex did not have to pay a filing fee, and that filing fee would have been $25 had she been required to pay it. But as I mentioned, she didn't have to do it here. If you'd like to, you can read the details on the form. It's not really that, difficult to determine whether or not you have to pay a filing fee. As long as you follow the instructions, you should be fine. So let us move on. Going into the aftermath, I obviously didn't file this document, so I incurred no costs. My ex mailed this to me, so let's just call that no costs. There was no service of process there. Also, she didn't have to pay a filing fee, so again, no costs. The attorney fees, I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney prepared this document. It is pretty bare bones. It is just one page with the facts and law. It is probably, I'm not going to say it's sloppy because it's pretty concise. It's just, maybe that's just the best she could do, because in reality, my ex was wrong. If you watch part 17 of the My Docket series, it's pretty comprehensive. And this is probably the best that my ex's attorney could do in this kind of situation, because she just didn't have anything to really show that her client was right. So she made a couple of allegations. They're plausible, but they're not true. And given the fact that it was so short, say 1 hour, even though she probably billed her more than just an hour, it's too short for me at this stage in the series where I've been so conservative all the way through, for me to go any further than that. In this case, it is a really short opposition, and she didn't even cite any points and authorities on her request for attorney fees at all. She just basically uses general principles of unfairness as to having to file this opposition. So all of that being said, we're going to go ahead and settle at 1 hour. So that is going to be $250 in attorney fees for my ex. If anyone has any questions, feel free to post it down in the comments below. And of course, you can always send me a message or an email at admin@theproperperson.com. And I will see you guys next time.